My name is Vince Tomich, and we're going to be we're going to have our partner Sharon Switzer, and we're going to bring her up shortly. I'm just going to go through a few quick slides in the beginning to for those of you that maybe have never been on or are new to us here at Marshall Reddick. So really excited to have you guys. So again, for those of you that are new to Marshall Reddick, I wanted to explain a little bit more about us. So we are a full service residential real estate firm, and we focus on three primary services. Those being real estate brokerage, private money lending, and property management. So for our real estate brokerage, we work on helping buyers and sellers with their buy and sell their properties here locally in California or across the United States in one of our 16 markets. For property management, so 99% of those investors who own property use a property manager, and we'll be able to handle everything from A to Z. So that's marketing the property, background checks, rent collection, rent disbursement, repairs, even up to eviction. So we'd handle everything for our owners. And then for our private lending department, we actually have two clients there. So we have our borrowers and we have our lenders. So for our borrowers, we actually have people who are looking to do short-term, maybe fix and flips, or builders looking to build spec homes. We also have those who want to use their solo 401k or self-directed IRA to invest in real estate. And therefore, they would need a non-recourse loan, and that's what we're able to provide. On the flip side to that, we actually have lenders who are interested in the same way that a buyer would invest in real estate. We have people who are interested in investing in mortgage notes. So whether those are long-term or short-term, the interest rate varies, but that's the gist of the private lending department. So a little bit more about myself. As I mentioned before, my name is Vince Tomich. I'm an advisor here at Marshall Reddick, and my main objective as an advisor is to learn about each investor's short and long-term goals and be able to help them accomplish those. So I have a background in residential mortgage lending. I was in that industry for about 4 years, and that's where I really developed my interest in real estate. Learned a lot about the leveraging property, leveraging your money to acquire property. So living here in Southern California, when you're looking at the prices here, it sometimes is a little bit daunting to try to invest in real estate, and so it forced me to look outside of the Southern California market. So once I was able to realize that prices are much different once you leave California, it really invigorated me to want to get involved and want to invest. And over the last 3 years, I've been fortunate enough to invest in 3 out-of-state single family properties, and have just been growing and growing my interest. And the way I actually came across Marshall Reddick was actually through a webinar just like you guys are on tonight. And once I was able to eventually start spending more time on their website and looking at properties and looking at all the other ways to invest, and once I got involved and was able to meet part of the team, I actually became a client myself. So that's what really pushed me into going full-fledged into this industry. So really excited to be here. Really excited to be able to share with all of the other partners that we work with. So I want to go in a little bit of how we choose where to invest in property before we get into the estate planning. So as I mentioned, we're in 16 different markets across the U.S. and there's a few things that we really focus on prior to picking a market that we're going to spend our time in. So one is we want to make sure that they have a steady job market, and want to make sure that the job market is steady so that we know that people are going to be moving there. We also want to make sure that there's a low vacancy rate. So want to make sure that we're able to fill these properties once an owner is able to acquire one. Economic diversity. So we don't want to hinge, on one industry to support the whole, all of our renters. So it's really important that we're able to diversify jobs and be able to have multiple industries, so that in the event there is some kind of collapse, that the properties are still stable. Another element is what I just recently touched on, was housing affordability. So like I mentioned, here in Southern California, sometimes it's difficult for those to invest. So we want to make sure we're in markets where the numbers make sense, and it's in the range for as many people as possible in terms of purchase price. Would love strong education, and then finally reliable property management. So that kind of leads me into my next slide. So what you're going to see here is the 16 markets that we do business in. Within those markets, you're going to see some of these cities are in a red box. So the red box indicates, where we have Marshall Reddick offices and where we do property management ourselves. So it's we are trying to grow into being able to do property management in all the markets we do business in. Although it does take time setting up those offices and those people to deliver that, quality of service that we deliver. So with that, we're slowly, growing city by city, and we plan to definitely be expanding, in the near future. So I want to be, again, before we get into the estate planning, I just kind of want to go over some sample, a market that's been really popular for us, and that's the Clarksville, Tennessee market. So what I have in front of you guys here is, the metropolitan statistical area prices, right? So we have these prices from 1996 to 2018, and what we're able to break down is show just a slow and steady trend for appreciation. So in particular, the Clarksville market, it doesn't, some of you might be looking at 2.88 or just under 3 and saying like, well, that's relatively, not a whole lot. And it is I would say a fair appreciation trend, but the point to look at is this steady increase over time. And Clarksville tends to be one of our markets that is definitely more cash flow heavy. So that's something that also is really interesting to our investors. And I'm gonna kind of touch on that on the next slide. So so what we have here is we just have a little bit of we have a breakdown, a simple pro forma of what some of the numbers look like in the Clarksville market, just as an example. So we're looking at these purchase prices, and this home here is looks like it is 115,000. So this is what the numbers would look like putting 25% down. So just under 29,000 for down payment, about 5,600 in closing costs. So your all in is about just under just about 35,000. So you can take a look at some of the numbers when we factoring your rent, you're backing out your mortgage payment, your taxes, your insurance, your property management, and with that, you'd be looking down at a income of about 270, just about 275 a month. And then we also factor in our variable expenses, which are maintenance and vacancy, which are really important to consider because it is something that will happen over the life of the investment. Although we really try to mitigate that with really good property management and really qualifying our tenants. So something to take a look at. We can definitely touch on this if anybody's interested in looking at more property. We can definitely touch on this, later with my follow-up. So at the end of this presentation, you can expect me to call to, try to set up a consultation with you guys, and depending on what you're interested in. And the whole goal with these consultations is to figure out the who, what, when, where, and why, right? So why would you want to invest, or why do you want to set up an estate plan, right? How would you do it? So, for properties, do you want to buy cash, or do you want to use a loan? Do you want to use private money lending? There's multiple ways to do that in a time frame, right? So when does it make sense to do this? Are you in the middle of maybe switching jobs, or are kids going off to school, or do you need money now for some kind of a remodel? So there's a lot of deciding your time frame is really important, and then setting your criteria in terms of what types of properties you're looking at, also really important. Whether it's a duplex, a single family, a four unit, even up to up into the 5, 6, up to 10 units, right? So definitely want to establish what we're looking for, and then identifying markets is, I would say, one of the most critical elements, because different markets warrant different types of results. So we have some markets that are a little better with cash flow. Some markets are a little less cash flow but have much stronger appreciation. So it's all about figuring out what's most important to you, because not all investments not one investment doesn't make sense for everyone, right? So some people might be looking for different things. So, and finally, the who, all of the key players involved. So there's myself, who's a real estate advisor. There's actually our real estate agents in each individual market. We have our lender in place, great property management, and then we also have partners like Shannon, who once you've been able to acquire and set up these types of investments, it's the most important to be able to protect them for the future and family members. So that's where we're gonna transition into now. But before we do, what I'd like to do is take a quick poll, just to make sure everybody's still here with me. So what I'd like to do is just get a quick poll and see which one of these best describes you. So I'm going to go ahead and start that poll now. And just so you know, all of the results are anonymous. None of this information will be shared. We'll just see the results of who clicked what, but ultimately everything is private. So which one of these best describes you? I do not own any real estate yet. I own my primary residence, but no investment property. I own investment property, but not my primary residence. And I own both my primary and investment property. So I'll give you guys about 10 to 15 seconds to go ahead and click this poll, and we'll get a little better indication of where we are. Okay. Okay, a couple more seconds. We'll wait. All right. So we'll go ahead and wrap this up now. So we have closed the poll, and now I'm going to be sharing those results. So it looks like we have 28% I do not own any real estate yet. 13% I own my primary residence, but no investment property. Only 5% I own investment property, but not my primary residence. And there's a large majority of you, 54%, so more than half of you guys own both your primary and an investment property, which is great. So that's showing me that you guys are in definitely the right place to get involved more in the estate planning and what you can do to protect that. So we're going to go ahead and move on. Okay, so next, I want to introduce Shannon Switzer. She is going to be our guest to further explain estate planning, wills, and trusts. She has been in the industry for a very long time, and she has a wealth of knowledge in this department. And I'm going to turn it over to her to introduce herself and to start her presentation. So Shannon, feel free to take it away.
Great, thank you very much. I'm going to see if I can actually make this so that I can take control of the screen. I have to admit to everyone, this is my first webinar on either side of the equation, so hang in there with me. And I think that the term, she's been in the industry a very long time, is just another way of saying that you're old. So hopefully we can put that oldness to good use. I will do my very best to try to use the slides effectively, but I will say that this is a great example of do as I say, not as I do, and listen to what we're talking about topically versus necessarily the depth or topic on the screen. So I'll do my best with that. Essentially, we're here to talk a little bit about how best to transfer your assets after death. And in addition to that, how to provide for someone to care for you and to manage your assets if you were to be alive but incapacitated. So let's talk a little bit about those different concepts. Essentially, when you die, there's really only one of three ways to transfer your assets. And those ways are what we're seeing here on the screen now, which is if you pass and you have absolutely no kind of a writing or document in place, we call that dying intestate. And under those circumstances, the default laws of the state in which you pass are going to determine who gets your stuff. So from a planning perspective, obviously, we don't think of that as much of a plan. So then that takes us to the two remaining concepts, which is either a will, which is a standalone document and is a public document that will go through the court system, or a trust, which is a private document similar to a contract that skips the court process and is overseen outside of that realm. So let's take a look at some of those comparisons between those three. Again, intestate succession from a planning perspective is really no plan at all. So just to give you an idea of what would happen to your things, for example, in California, the law basically follows what we call the table of consanguinity. So that is just looking for relatives that are related to you by blood. So it looks to whether or not you're married as a first blush. And then it says, okay, well, do you have children? And if you don't have children, are your parents alive? If not, do you have siblings? Do they have children? And it goes on and on and on in those blood relatives to the nth degree until they find people that fit the category. So again, setting that aside and considering that not to be much of a plan, that really leaves us with the two choices between the will, a public version, and the trust, the private version. So essentially the will, because it has to be, quote, public, it's really as though you are saying, here's my intention. So judge, I need you to take a look at this and honor my wishes by putting this through the process. So the probate court, the infamous probate that we hear so much about in California, is a court-supervised administration of the wishes of your will. So the downside to having to quote probate in California is that the time frame and the fees are significantly impacted by our court system and our laws. So the time frame is really more like an 18 to 24 month turnaround time in today's world, because we have so many bodies trying to fit through our court system. We simply can't get through much quicker in that time frame. In addition to that, of course, there are minimum timelines required to go through the court system, notification to creditors, things of that nature that simply take, at a minimum, a 9 to 12 month window of time. But practically speaking, we're looking more at 18 to 24 months. So there's a delay process that's a consideration. And the other thing is that we have mandatory fees in California. So there are several states that don't require these mandatory fees, but in California, instead of compensating the attorney to help you get through the probate and the court system by the hour, we actually compensate the executor and the attorney by virtue of a percentage of the assets that you own when you pass. So for the first $1 million worth of value in your estate, the fees are $46,000. And then for every $1 million after that, it's 2%, 1%, et cetera, as you get higher up the rung. So really, some people find it offensive that instead of the lawyers getting paid for the time and effort they put in, they're actually making a boon off of how much you've been able to acquire during your lifetime. So that's one of the reasons why you hear so many negatives in California about the concept of probate. Let's take a look at the next slide. Hopefully, will give us, I no longer have control of the screen. There we go. Apologies. So let's take a look. I was highlighting for you just a moment ago the disadvantages, if you will, of having a will. The contrast to that is the advantages of having a will. A will is generally, an estate plan based on a will is generally slightly less expensive because instead of having a trust and its companion documentation, the will is a slightly simpler document to create and requires less transfers and therefore less lawyer time. The other upside to having a will instead of a trust is that once you have the will created, you simply take the will and put it into your drawer, and it doesn't have any force or management impact until after you've passed. So that's a little bit simpler and cleaner than the additional legwork of a living trust. And then finally, there are those who would argue that because the terms of your will are overseen by a judge in the court, that there is a better guarantee that those things will come to fruition than a private document that is not overseen by any judge or adjudicator. So when we're talking about having to compare and contrast these things, we want to look at the advantages of the will and the disadvantages of the will, and then we want to compare that against the alternative, which is the private document, the trust. So let's take a look at what the trust lays out like and what those advantages and disadvantages are. So in a trust, and again, it's most commonly termed a living trust. Its true and correct term is a revocable trust. So this is a trust that you create, and that calls you the settlor or the creator. You manage it during your lifetime as the trustee, and you are the recipient or the beneficiary of this trust during your life. So you or you and your spouse create this thing, you operate it as the trustee, and you benefit from all of your assets as though they were individually titled during your lifetime. So it's only the fact that this trust creates a successor person to step into your shoes that allows it to end run the probate process and make it a quicker, arguably more seamless transfer when you're gone. So the trust, by contrast to the will that gets created and then put into the drawer, is going to take 2 steps instead of 1. And that is we create and draft all the terms and conditions that you would like to see happen on your passing. And in addition to that, with the trust, unlike the will, we have to take your assets, so your real property, the home you live in, etc., any kind of investment accounts or bank accounts, and we actually have to transfer that instead of in your name individually to your name as trustees of the name of your trust. So it's a 2-step process instead of the single-step process. So when we're doing this compare and contrast, advantage versus disadvantage, the advantages are that we're not going through the court system, so we don't have to have the delay in timelines and mandatory fees. The other advantage for the trust is that it's generally less expensive on the back end. So we talked about the fact that the will might require less lawyer time to draft during your lifetime, but would be more expensive on the back end for your heirs. Whereas the trust is the exact opposite. The trust, since we have to do some transferring of assets, might be a little bit more expensive to set up on the front end, but is generally much less expensive by way of lawyer fees and fees on the back end because they're not mandatory. And your successor trustee simply has to have the expertise they need to do the job. So an estate planning attorney would do trust administration and help them. SCPA would file final tax returns and things of that nature, but they would only pay them for the time that their efforts and energy were charged by the hour. So it's generally less expensive for the people receiving your assets. And then, of course, the timelines and delays related to probate are the opposite here in the trust, in that it can move more quickly based on more truncated California laws and as quickly as you can acquire the assets and distribute them according to your wishes. So those are the advantages under the California law of having the trust. And then arguably the disadvantages would be some of the things that we were just talking about, which is slightly higher establishment cost and the fact that you've got to transfer your assets into the trust. So it's a bit of a nuisance during your lifetime to make sure that it's properly transferred. And then as you acquire new assets going forward, you're going to want to be sure that you're acquiring them in the name of the trust. So instead of me buying a piece of property in my name, I'm now buying a piece of property as Shannon Switzer, trustee of the Switzer Family Trust. Not a big deal once you get used to it, but it's one of the things in the balancing process that you want to be sure you're considering. And then lastly, one of the advantages we talked about the standalone will was that the court would oversee the distribution and administration, therefore thwarting any kind of mismanagement, presumably. Well, since the trust doesn't have that oversight, some would argue that the disadvantage might be the private document doesn't have oversight and therefore could be mismanaged. And while I think that is a legitimate concern, I think that that is balanced out by the fact that we are choosing the trustee, and hopefully that we've chosen well in who it is we're putting in charge of doing our bidding. So I think that those are a balancing act between the two. So I think the important thing here is that you'll find that by far and away in California, because we are working with mandatory probate fees, people side on the perspective of probably doing much more living trust-based analysis and setup than we do the other. But it's really just a matter of you choosing which of those two areas is of greater concern. I think you'll find there are people out there who are perhaps older. I've had a couple of clients in their 90s who didn't have children or family that they were benefiting, and instead were just giving assets to charitable organizations and things of that nature, and they didn't have a plan in place. So they said, you know what, I'm 95, I'm 97, I don't need to go to the hassle of creating this trust for the benefit of these charitable organizations that will get my stuff. And I don't care if it takes 2 years to get through it and get it distributed. It's not taking care of my kids, it's not taking care of my grandkids, etc. So I'll just take the slightly less expensive, easier route for me and let the back end pay the higher fees and take the greater time. And if that's your perspective, then a will-based estate plan is probably your better approach. The flip side is, if you're willing to put in a little bit more legwork up front, then you can take a little extra time on the front end and save the expense and time on the back end for those who will be receiving your assets. So it's really just a balancing act between those two concepts and those two places. Let me see what is next in our slide. Okay. Real quickly, it looks like Vince has set up yet another poll, so I'm going to turn it back over to Vince. Let him jump in.
I will go ahead and get that started now for us. So everybody stand by for 1 second. Let me get that started. Okay. So same type of question. Which one below describes you best? 1, I am interested in setting up a will. 2, I'm interested in setting up a trust. 3, I'm interested in setting up both. Or I am not ready for any estate planning yet. So I will give us another maybe 20 seconds to get everybody's votes in so that we can go from there. Okay, so we'll go ahead and shut the poll down. So we have, I'm going to go ahead and share the results. Again, they're all anonymous. We bring in the percentages. So I have now shared the results. So we have only 5% are interested in setting up a will at this point, 31% interested setting up a trust, 36% setting up both, and 28% aren't ready. So it's, fairly even across the board, at least with the last three options. So we'll go ahead, and now that we have a little indication of where people are as of now, we'll go ahead and resume. And let me just get it set. Let me get the presentation back to the next slide, and we will have Shannon take over again. So stand by. Okay, Shannon, you're ready to go.
Okay, great. Thank you. All right. So far, I still see the poll, so give us just a second, and we'll see if I can catch up to where you all are. I think I have control, so I'm going to see if I can catch us up. There we go. Before we jump into the concept of the estate tax exemption and estate taxes, I wanted to clarify an issue on the idea of a will versus a trust. So what I should have said when we talked about this is that we're comparing and contrasting a will that stands alone and is the sole estate planning document for the purpose of distributing assets versus a trust, and every trust should have a little companion will. So what I mean by that is when you establish a trust, you take everything that you own and you title it in the name of the trust, and that is what allows a successor trustee to step in and have dominion over those assets when you pass. But to the extent that everything doesn't always perfectly make it to the trust for titling purposes, every trust should have a companion will that we call, just as a term of art, a pour-over will. And what that will says is, hey, if something's been left out of the name of my trust and is actually in my name solely, please transfer it into my trust and distribute it according to my wishes under the trust. So a pour-over will comes from the term that it's pouring over into the trust. So that's all that is. So just to be clear, I just want to make sure that I'm clear about articulating that. When we say a will versus a trust, we really mean a standalone will or a trust with a little companion will. So you should never have a revocable trust without a companion pour-over will to go with it. Okay, so let's talk about the next layer of nuance, which is something to consider for everyone, whether you are in a spousal relationship or single, and that is that when you pass, the federal government says you can give away up to a certain dollar amount without any taxable consequence. But every dollar after that dollar amount is taxable. Today, the tax rate is 40%. So the estate tax rate in today's world is 40%. A couple decades ago or so, it was a graduating tax of up to 55%. So we are completely and totally at the whim and discretion of Congress as to both what the tax will be for the estate tax and what the exemption amount is. So the exemption is that amount that is free. You can give away up to that dollar amount, tax-free. So in today's world, as of the last 2 years, we have had an enormous exemption amount. It is $11.4 million that each person can give away tax-free before we have to worry about any estate tax. So you can imagine when that number became so high that it really genuinely affected very few households in the nation. There just simply aren't that many people that hit the category of individually having $11.5 million or collectively of spouses having $22 million. But when I began in the estate planning arena, that number was $660,000. So in 25 years, that number has gone from $660,000 as the exemption limit to $11.4 million. So it is completely, we plan in terms of the unknown, and we do the best we can with what we have to work with at the time. So proper drafting for estate planning will apply the estate tax exemption at the time of your death. And of course, we don't know what that will be, so we just do the best we can to plan accordingly. You'll notice on the slide here that it makes reference to this exemption amount sunsetting in 2026 to $5 million. So 2 years ago, the estate tax exemption was $5 million. And you'll notice the next line on there says it's indexed for inflation. So really each year, $5 million became a slightly greater number, 5.1 million, 5.2, etc. Then in 2018, the new administration passed a law in which we bumped up the estate tax exemption to the $11 million mark. But part of that law said, barring any other act of Congress, as of 2026, it will sunset back to the $5 million amount. So as you can imagine, it's anyone's guess where we end up. So the key is that when we're planning, we plan accordingly to take advantage of not one, but two exemptions in the event that we have spouses. So we'll talk about that in a little bit more detail. But one of the things you need to be concerned with is if you are anywhere near the threshold of these big, numbers, when you are acquiring assets, you want to be sure that you're speaking with your estate planning people, both accountants and attorneys, to talk about sort of more advanced or additional items you can add to your core revocable trust. So the core trust that everybody should have would be a revocable trust that you have complete dominion over, that you can change anytime you choose, that you can sell anything, buy anything, do anything you want to, amend the terms and conditions, etc. Whereas an irrevocable trust is either your trust after you pass, which becomes irrevocable and unchangeable because you're gone, or it's a trust that you can set up during your lifetime whereby you have given away dominion and control, like a charitable trust, where you take money and you donate $1 million to the irrevocable trust for some exchange in tax benefit, etc., but with the understanding that the trust can't be changed, you can't be in charge of it, and you can't take back the money once you've contributed it. So setting aside irrevocable trust, the core trust we're talking about is a revocable trust. So moving on to this concept of how do we best plan for the estate tax exemption, one of the considerations is that you can set up a special kind of trust. You can also do this under a will if you choose. It would just have to go through probate before creating these trusts. And that is, we can set up a trust that splits itself into two subtrusts or more, depending on how many assets, on the death of the first spouse. So for married couples, we want to plan at a little bit different level. And the reason we do this is because the exception to the rule, which is the rule that I can give away so much up to a certain dollar amount after which it will be taxed on my death, the exception to that rule is that I can give an unlimited amount of money to my spouse. So unlike being able to give it to a child and having to pay tax over the $11 million, I can give my spouse $100 million and not have a taxable consequence when I pass and give it away. So that makes it sound at first blush as though you would want to simply, if you were the first of two spouses to die, give all of your half of any community property and separate property to your spouse. Because by doing that, there's no taxable consequence. The problem with that is that when they pass, if they were to give it to, let's say, your children, they only have one estate tax exemption. And we've piled both your stuff and their stuff into one big pot. So if you had $30 million between you, and on the death of the first of you, you gave your $15 million to your surviving spouse, they now have $30 million, and if they were able to not spend it down, they'd have $30 million when they died to give to your children. But they only have one estate tax exemption, so they can only shelter $11 million of the $30 million from taxes. But if instead we created these two subtrusts on the death of the first spouse, when the second spouse passed, pot A and pot B would both go to the children, but each pot has their own exemption amount. So we could shelter $22 million of the 30 from taxes. So there is a reason why for married couples, we do this sub-trust planning. It's commonly called AB trust or AB planning, or in today's world, if you have enough money, it's called an ABC trust. And the concept again behind that is we are sheltering these exemption amounts for the purpose of distributing them to the next generation or to the next beneficiaries after both spouses are gone. The other element to that concept is a control element. In today's world, we are dealing with equally as many blended families as not. So you and I are married, we each have children from prior marriages, and when I go, I don't mind sharing with you and making sure you have what you need during your lifetime, but whatever's left over when you're gone, I want to go to my children, not your children. And when you're gone, you want your share to go to your children, not my children, or any combination you can envision that comes of that scenario. So an AB split or an ABC split as of the death of the first spouse gives both control and estate tax benefits. So there's an important element there to explore in the event that you're in a marital situation. We want to be sure we plan that accordingly. Let's see what else is on here. I'm going to skip this next slide for just a minute and hop over to some of the additional documents that you should always be considering as part of a comprehensive estate plan. And those are documents, you'll notice that the will and the trust are listed as 1 and 2. And then you'll see that there is an advanced healthcare directive and a durable power of attorney. These documents are critical documents that are applicable only during your lifetime, but in the event that you were to become incapacitated. So an advanced healthcare directive, you might also hear called a durable power of attorney for medical needs. That's a document that says, hey, I'm going to name people and I'm going to give them some guidance in my document that are empowered to make medical decisions for me if I become incapacitated and I am unable to make those choices for myself. So it could be that you are physically incapacitated, you've been hit by a bus and you are in a coma and you can't make choices for yourself during that time period. This person is empowered to step in and make those choices based on the guidance you've given them. Now you wake up 3 days later, you're back in charge and you make the choices for yourself. The alternative and much more common of a way that we are seeing healthcare directives being used is that people are suffering from different forms of dementia. And once you've been diagnosed with dementia, you're no longer able to create one of these documents. So when your mental capacity has been determined to be fading, and when indeed you are showing symptoms of incapacity, then no one is in a position to step into your shoes to make medical decisions for you or to care for you unless they have one of these documents, or alternatively, they have to go to court to get what's called a conservatorship. Whether it's a conservatorship for your healthcare in your person, or it's a conservatorship for asset management, that is a long process, 3, 4, 5 months of court time, waiting and noticing, and it's expensive. You know, it's probably $5,000 in legal fees to get through an uncontested version of this. So if instead you had simply done a healthcare directive and a durable power of attorney as part of your plan, then someone simply steps into your shoes during these periods of incapacity to take care of you, either your healthcare needs, or in the case of a durable power of attorney for assets, somebody steps in for those assets that would be outside if you have a trust-based version of your trust. So if you were trust-based in your estate plan, the bulk of your assets would actually be in your trust, and a successor trustee could step into place to take care of those assets. But there are also things that simply can't be held by a trust, like, for example, any Social Security benefits or pension plans, IRAs or 401k plans. Those are things that are carve-out specialty items that are outside of a trust. So for someone to be able to marshal those assets and act on your behalf, they need to have this power of attorney. And of course, if you didn't have any kind of trust, but instead were a will-based plan, then there'd be no element of a trustee to step in, and a durable power of attorney would be the sole way during your lifetime, but in capacity, for someone to step in and pay your bills and take care of you. So these documents are critical companions that will save a tremendous amount of time and money and heartache for the people who are caring for you if they're in place during your capacity as part of your collective plan. It's a few $100s in legal time and a whole lot of heartache and savings on the back end. So let me go back for just a minute to what was the previous slide. This is just making reference to something I alluded to earlier, which is that concept of alternate or secondary irrevocable trusts or alternate planning. So at some point, if you get to the place in your planning where you actually are saying to yourself, okay, I've got so much stuff that I can consider in some capacity either gifting it away during my lifetime or setting it up into some form of trust, be it charitable or otherwise, that is taking it out of my estate for the purpose of valuation when I pass, and maybe, if it's a charitable trust, giving me a giant income tax benefit today during my lifetime. So there are additional techniques and plans, components and tools to put in place along with your core plan. You'll notice that the center item there, life insurance trust, that is something that could be applicable to anyone at any time that has a life insurance policy of any significance. So when the federal government, for the purpose of a state tax application, determines what you own on your death, so they're determining what you, quote, can give away for the taxes, they include the value of any life insurance paid on your death. So despite the fact that it wasn't a part of your estate, but for the fact that you died and therefore it triggered a payment, the fact that you have $1 million worth of life insurances counted as part of your assets when you die. So if you had $10 million worth of real property, investment assets, et cetera, when you passed, and a $1 million life insurance policy, you would have hit the threshold for the estate tax exemption. So as an alternative to that, we can take any substantial life insurance policy, put it into one of these life insurance trusts. We call them ILITs for short, which stands for an irrevocable life insurance trust. And the trust now owns the policy, and upon the death of whoever the named person is, you in this scenario, it will pay to whomever the beneficiaries are that you've named in the trust, just like you would name them on a life insurance policy. But by virtue of this setup, the federal government doesn't count it as part of your estate, and therefore we have removed it for the purpose of counting for the estate tax exemption. So that's just an example of more advanced or companion tools that you would use as part of your plan. But the core plan, going back to that concept, is if you are trust-based, a trust, a companion will, and these lifetime documents along with all of the transfer documents that transfer your assets into your trust. So I think that covers my slides. Okay.
Awesome.
So I'll invite Vince back in for the purpose of guiding us.
Thank you so much, Shannon. Appreciate it. So what we're going to do is we're going to actually open up the floor for a couple of questions. What I want to let everyone know is if we don't get to your question, do not worry. If you type it in and send it to us, it's basically logged, and we can follow up with you, whether it's getting you on a phone call with Shannon directly or getting the answer and getting it to you. So not to worry. So I'm just going to start taking them as they come. We're going to take about 2 or 3. So I'm looking at one right now. So Shannon, what I'm going to do is I'm just going to ask the question, and then if you want to just give us your best response based on that, if that works for you.
Sure.
Great. So question 1 is, if I am married and we have a trust, do we have to do anything on the death of the first spouse?
Okay. So let's talk about that concept. We were talking a little bit about the idea of this split. So we set up, the most common way for trust to be set up would be to have the spouses have a joint trust, and then on the death of the first spouse, have a triggering event that does something. The most common something is to split in half like we talked about and create these sub-trusts. And they can be as restrictive or as liberal as you can collectively agree on between the spouses. But one of the misnomers that you hear commonly from people that are in spousal relationships is the idea that if my spouse dies, I just inherently get everything that they had because, gee, we owned it together somehow. And that's not really how the law works, and that's not generally how title works. So whether it is because you have a will or you have a trust, there is always going to be an administrative task, several of them actually, that have to be undertaken at the death of the first spouse. So there's either a summary version of probate that comes into play if the surviving spouse is the recipient of the person's assets, or under the existence of a trust, there's going to be some shifting and titling related to these sub-trusts. And one of the things I see most commonly in practice is that people will make the mistake of doing nothing when the first spouse passes, and then the second spouse passes, and it's the heirs who have to try to unring this non-properly put together plan. So the plan was laid out for them, they just missed the first step, and they thwarted the whole process. So the answer is yes, very important. When the first spouse dies in a spousal relationship, there is always going to be at a minimum some tasks that need to be done. Hopefully not a lot, but there's always going to be something that needs to be done to set this up properly for the next step, which is after the second spouse is gone. And also for access to the first spouse to all of those assets and dominion over them. So definitely you want to be sure you get some help when those are the circumstances.
Great. Thank you so much for that answer. I'm going to take two more. So the next one I see is, how do we make sure we can select who raises our kids if both parents are gone?
Okay, great. I'm sorry, I didn't think to tell you about that for those of you parents out there with minor children. One of the critical elements of having your plan in place while your kids are young is the ability to include in your plan. So if it's a will that stands alone, it would be designated there. If it's a trust and companion will, you would still designate for the purpose of guardianship nominees for people that in the absence of both parents, you would like to nominate to the court and have them raise the children. And it might be that if you have a trust-based plan, the trust actually says, if both of us are gone, or if I am a single parent, I want it to go into trust for my children's benefit, but I don't want you to hand it to them because they're kids and they'll squander the money, or they don't know how to handle that, or they're not eligible. Instead, I'm going to give it to my brother, and he's going to be the trustee to oversee the stuff, the money. But at the same time, someone has to be in charge of, a guardian for, a caretaker for the children themselves. And that might be my brother because he fits both bills, but it might not be. It might be that I want my sister to raise the children in her home and my brother to manage the money that is going to help care for the children. So we would designate the nominee of the guardian, the person to care for the children, and make that the priority for the court, so that perhaps if there were equally situated people, like grandparents that may want to fight one another, or siblings of the parents that might want to fight one another, that the wishes of the parents are paramount because they're articulated in the plan. The court will then favor the wishes of the parents. So that's an important thing to consider if you have minor children.
Awesome. Going to take the last question. And like I said, guys, not to worry if yours does not get answered. We will be able to get to those. It's just we are running out of time. So wanted to do the last one. So question is, how do I make sure that someone can care for me if I am too ill to make decisions for myself while I am alive?
Okay, so that's just an expansion on what we talked about sort of near the end here, the idea of the healthcare directive and the power of attorney. And again, in a rare case, some people actually choose to have their healthcare directive and power of attorney be effective immediately. So for example, if I'm ill, I might choose to give away my power today to the person who is going to help make those choices and do those things in caring for me, whether it's physically or asset management. But much more commonly, we're going to set those things up so that I have designated, and again, given, some guidance and direction to the agent. I'm going to designate the agent, and these powers are going to be what we call springing. So the power of attorney for both healthcare and asset management are going to become effective upon my incapacity. But by virtue of having these things in place, whatever that incapacity is, whether it's mental or physical, these people can step right into my shoes and make those choices and care for me. So whether it's mental incapacity and I will no longer regain capacity, and someone will have to have the authority to care for me, both physically and economically, or it's just a short-term physical incapacity, and I can recover from it, whatever that might be. The key is that these things are in place and ready to go at the moment of the trigger, and that's the most important thing. So having these things in place with an agent designated is what allows you to have comfort in the fact that someone can step in. It's one of the things that I talk to parents of teenagers going off to college about. We forget, because there's a presumption that these are our kids. We're paying the tuition and room and board for them, despite the fact that they're 19 years old. What it doesn't do is give us the ability to make medical choices or healthcare decisions for these children. So they go off to school, find themselves in harm's way. There isn't anybody eligible to make the choices for them absent a conservatorship, except for someone who has one of these healthcare directives. So whether you have an 18-year-old that you're looking out for, or it's you and you're 40, 50, 60, or you're 90, whatever it is, at whatever stage of life, if you're over 18, nobody gets to step into your shoes and make choices for you, both medically, and nobody gets to step in and take dominion over your assets, unless they have a court order to do so as a conservator, or they have one of these documents that empowers them. So they are an enormous time, cost-saving, and heartache-saving thing to have one of these in place. So I can't emphasize that enough as to their value.
Wow, thank you so much for sharing that and answering that so well. So that's all the questions we're going to take for tonight. But like I said, we will be able to get back to you guys if you have more questions, or we can put you directly in touch with Shannon if you guys want to dive deeper into maybe like a more personal matter that has more specifics. So I'm going to go ahead and go just to the next slide here. Bear with me while I take control. So those of you that are new to Marshall Reddick, I want to point out our educational tab, basically our Learn tab, and all of the education that you can find there. So all of our webinars, that like the one we're doing tonight, are all recorded and they are all posted on our website. You can find webinars on articles, data reports on various topics. This is one of the topics. There's a ton there to go over. So there's a wealth of knowledge that you can find. And if you have any questions about something specific that maybe we've done in the past, I can personally help guide you to finding that content. So really important to check out. Also, we have a free ebook that we wrote, and it's really cool if you're considering purchasing investment property. This kind of breaks down our philosophy of how we rate properties and what each property class indicates in terms of like an investment, and what kind of clients and what kind of repairs and maintenance you can expect depending on the the property type. So, the property class. So really cool read to get a little more familiar with that. Again, so I will be reaching out to those of you that attended, get a little feedback and see if there is anything that we can help cover. I will definitely be someone who can help get you in touch with Shannon and set that consultation up if you guys wish. So you can expect my call. My contact information is here. We'll also be sure to share Shannon's contact information with everyone. And it would be nice before you guys, before we log off, if we can just have you guys take a very quick survey. So as soon as I end the webinar, a survey, 3 questions will pop up, and it gives us great feedback, and it allows us to better serve you and improve these presentations. So want to thank Shannon so much for your time tonight. We really appreciate all of the information, and we appreciate all of the attendees and your time this evening. I hope this was very valuable, and like I mentioned, I will be following up with you guys after this presentation. So thank you all, and thank you again, Shannon, for your time.
My pleasure.
All right. Have a great night.